All right, here with me to break all this down and discuss criminal defense attorney Melaney LaGrone and trial attorney Jamie White. Jamie, I'd like to start with you if I could. Tell me, the evidence now presented that this casing was found 5 months after the murder on the back porch where the body was found. Is that possible from your perspective as a trial attorney?
So anything's possible, right? I think the question becomes is, does it create enough or at least substantially part of something that gets the defense to reasonable doubt? There certainly are some strange components to this, Ashley. You've mentioned the time associated between the killings and the location. It's my understanding that the police did a very thorough search of this area. If I'm not mistaken, a tooth was located in the same area, but yet they seem to overlook a shell casing. However, at the end of the day, that bullet came from the gun they found in the safe of his home, or at least the casing was associated with it. So that is a real problem. But there is a specter of unusual about it. There's no question.
Yeah, I don't disagree with you. I think that's a very accurate description of it. Melaney, what other thoughts do you have as you've listened to this testimony? What has stood out to you?
It all sounds a little suspect to me, because like everyone said, it's been so many months. And then did they move some furniture and they found the shell casing somewhere up under something, or was it just laying there? I definitely agree that there are a lot of issues with this shell casing, the way it was found, the length of time that it was found, and where it was found.
All right, I'd like to take the opportunity, because you're right, Matt testified as to the casing. Yesterday, the aunt, Diana Phillips, and that's Matt's aunt, the sister of the victim in this case, testified as to the casing. Let's take a listen to some of her testimony.
Did you discover an item on the back porch of your brother and sister-in-law's house?
Yes, ma'am.
Explain to us what you were doing on the back porch and how you discovered this item.
Okay. We had removed most of the personal items in the house. And so we were beginning to then work on areas where there wasn't personal items, i.e. furniture or jewelry or that kind of stuff. And so I was going through, they have this breezeway or back porch that is attached to the house. And so I was going through back porch, and I was looking for anything. Every time we go into that house, even still we own the house, I still look to see if there's anything that I could find of any relevance whatsoever. And that's what I was doing then. And so it was at that point in time that I actually then found what I now know to call a casing. At the time, I did not know the name of it.
All right, Jamie, if you would, help me break down the fact that it was found on the back porch. We already have testimony today from the lead investigator in this case that he was unable to find any pool of blood or any indication of where the murder actually happened. So put those two things together. What do you make of it?
Well, it's a great point. I was thinking about it as I listened to the testimony as well, Ashley, because, again, anything's possible. But I guess if you believe that this shell casing was expended from the 45 and left at the time of the shooting, you'd have to believe that there should be some physical evidence of that shooting where that 45 was located. Without that logic, I think you have to get into sort of the who shot JFK magic bullet theories about how that casing would have marched with the body, so to speak. And that seems a little unreasonable to me. The setup theory or the cover-up theory, whatever you want to call it, that appears the defense intends to go down, I don't know if that is the right way to go. But I do think that at the end of the day, they don't have to prove that. They just have to show that it isn't reasonable that that casing would be in that location. And all of the other variables that we've already discussed based on the unusual nature of it.
Yeah, excellent point. The state has the burden. The defense doesn't have to prove anything. They just want there to be reasonable doubt at the end of the day. All right, Melaney, Jamie, you're going to stay with us. We do need to squeeze in a quick break, but when we return, we're going to look at another piece of evidence that linked Christian Martin to one of the scenes of the crime. That's up here next on Court TV Live. Welcome back to Court TV Live. I'm Judge Ashley Willcott. Now, during testimony of Pam and Calvin's son, Matt Phillips, another key piece of evidence was brought up. Matt's Aunt Diana testified yesterday about finding dog tags that belonged to the defendant, in this case, Christian Martin. And earlier today, Matt testified about the location of where exactly those dog tags were found.
Matt, I'm handing you what's been marked as Commonwealth Exhibit 1. Is that the dog tag?
It is. That string, anyway.
That string?
There's a picture with that string in it that I believe they later saw.
The police?
Yes, from the crime scene photos. So there's like a built-in shelf. You walk in the back door, built-in shelf is on the right. There was a like 1950s refrigerator in that room, but that built-in shelf had a lot of different, like old books and just stuff. You put stuff on a bookshelf. And it was probably the middle shelf up, if you will, some elevation. So, if you walked by this bookshelf, you wouldn't see it down. It's not a very large item. And that's where she found it.
Would you describe to us what you located and how that occurred?
Yes, ma'am. In the process of going through a 4,000 square foot house, you're trying to figure out, again, what things to keep and what not to keep. And there was a bookcase that was built in the foyer. And so I was putting stuff, bringing stuff down and trying to figure out, again, what to keep. I did not have my glasses on. And so anyway, so I took a dog tag. It was a dog tag. I brought it down. It was up on one of the top shelves. And I actually took the dog tag and I kind of held it to my chest because I thought it was my brother's. And so Matt came over and I said, look, it's your dad's dog tag. And he looked at me and he said, Aunt Diana, get your glasses on. I said, okay. So I got my glasses on, and it was not my brother's dog tag.
What did it say?
It said Christian Martin.
And what did you do then?
I was shocked and I was stunned. And candidly, at that point in time, I remember crying and thinking, now what? Now what do I do? And so we got a baggie, and I put the dog tag in a baggie.
Joining us here on Court TV Live, criminal defense attorney Melaney LaGrone and trial attorney Jamie White. I'd love to start with you, Melaney. All right, she was shocked, she was stunned. Well, who wouldn't be? Why could those defendants' dog tags be in their house? I think that's a compelling piece of evidence to at least link him to that house.
Yes, but at the end of the day, why would his dog tags be in that house? And usually people don't take, who are in the service, they don't take their dog tags off of their neck, from around their neck. So how did it get there? It's a little strange to me. Not quite sure what to think about that, but I wonder why the dog tags would be there, because he wouldn't just take them off and put them in the house. And I don't think he would even drop them, let's say, if he was there in the house. So once again, another piece of evidence that's a little suspect.
Right. I think it's suspect, but Jamie, it doesn't necessarily mean just because his dog tags were in the victim's house, he killed the victim. But it does make one question and wonder, why were his dog tags there? He must have been in that house at some point in time.
I don't know that we can jump to that conclusion. This piece of evidence is far less compelling to me than the shell casing. Melaney is correct. I was prior service. You keep your dog tags. You don't throw them away, and many people wear them. But what's unique here is the victim was also a veteran, based on the testimony of his sister, and people who are in the service also don't throw other people's dog tags away. So first of all, it's on a shelf. It's on a shelf that isn't arguably anywhere near any homicide scene, at least one that could be proven. So I think we can presume that someone put it on the shelf. But I guess, we can make these guesses, and that's the point, Ashley. I don't think this proves anything in a convincing way, certainly not beyond a reasonable doubt. And I don't think it proves that he went in that house. I think it proves that at some point in time, somebody saw a shiny, bright object and realized it was a dog tag, and it ended up on that shelf in some fashion. So this piece, I understand why the prosecution is pushing it, but I think it's far less compelling than the shell casing.
And to your point, it could have been found. He could have lost it. Somebody found it on the street, found it next door. It just ended up there. So you're right. Now, we don't know what other evidence the prosecution is going to present. They've only been through 4 of their witnesses, a triple homicide. We can expect, obviously, more witnesses by the prosecution. If I could start with you, Jamie, how do you feel like the prosecution has fared on presenting the evidence thus far?
I think they've been effective. They're taking their time. I think that they've been setting up, I think they've done a good job at presenting both the human side of the victims and producing the evidence. They came right out with the lead detective, which is unusual. In the homicide cases that I tried as a defense attorney years ago, they always ended with the lead detective to clean everything up, because I think what we're going to see over the course of the next couple of days, I presume, are going to be your classic chain of evidence witnesses and sort of the blander flavor. But they started right out, with family, created some emotion. There were some evidentiary issues there, then went right to the lead detective. And then that's an unusual strategy based on my experience. We'll see how it plays out for them.
Right. And I do think that they've really been, so far, providing evidence that is what they said during the opening argument, they being the prosecution. This is what we expect the evidence to show. All right. I'd love, Melaney, your additional thoughts on the prosecution and how you think they're faring up until this point.
Absolutely. I definitely agree with Jamie. I think they are doing a pretty good job, very slow and precise in everything that they do. I was definitely a little not taken aback, but I was wondering why the lead investigator was up there first off. Because usually they'll do the chain of custody with all the different police officers and everyone that, was at the crime scene on up to the lead investigator and what ended up, panning out after his investigation. But at the end of the day, I think they're doing a pretty good job, and they are, the way that they're presenting everything, I think it's easy to follow.
All right. Thank you, Melaney and Jamie, for all your great insight. I know you're going to stay with us to continue to break it down. Christian Martin was arrested and charged with murder on Mother's Day of 2019. And the news of his arrest literally sent his mother to the hospital.
Can you tell me about your reaction to learning that he had been arrested?
Oh, I can tell you that was an awful day in my life. I ended up with a heart condition that day in ICU, which was followed up with surgery. I mean, that was that much of a shock. And it was Mother's Day, I think, that it happened.
It was May 10th, 2019.
It was Mother's Day, 2 years ago.
Welcome back to Court TV Live. I'm Judge Ashley Willcott. Always my privilege to be with you. Chris Martin's mother, Jane, was in court for the opening statements, and it was the first time she had seen her son in person in 2 years. Court TV legal correspondent Julia Janae spoke with Jane Martin about her son and how the news of his arrest literally sent her to the hospital. All right, we're having a technical issue, so I'm going to bring back in criminal defense attorney Melaney LaGrone and trial attorney Jamie White. All right, let's talk about, first of all, I was just saying off air, 2 years to not see someone during COVID, regrettably, has been the norm for many people to be safe and prevent during the pandemic exposure. But add to that, the mother of the defendant not only has not seen him, but it's also because he's in jail. How does this affect, let me start with you, Melaney, as a criminal defense attorney, or does this affect any arguments you have on behalf of criminal defendants to be allowed to get out of jail on bail or bond?
Well, of course, one of the arguments for, bail or bond is whether or not they have ties to the community, and things like that. So the fact that he would have family here, and if he had not seen his family in a while, possibly that could be an argument. But again, with certain type of charges like this, it's rare that it's even going to happen that someone is able to get out on bond for, this particular type of charge. So, it's always an option to use it. And I do believe because of COVID and we've all been so separated from our families for, a year, that would have been a good, maybe heartstring, to pull on the judge.
All right, those are all really great points. And let me ask you, Jamie, so, we're noticing now as we continue to cover these trials live that now we're seeing court proceed without masks and precautions are still in place, but it feels like perhaps we're starting to return to normal in terms of pre-COVID court experiences. Tell me, Jamie, what your thoughts are. Do you think that we're headed in the direction of returning to normal full court calendars and trials without as many precautions?
I suspect that a lot of the precautions are going to be dropped, in the relatively near future, at least here in Michigan where I practice. But I can tell you, our Supreme Court administrator just issued an edict yesterday, highly suggesting that local courts continue to utilize Zoom, for all sorts of reasons, everything from cost effectiveness to proficiency and access to courts and so on. So I think the pandemic has had a permanent effect on the courts, not only in states, but, federally as well. How it all plays out over time, I think we're going to see a slew of first impression appeals as these convictions start to come across as a result of COVID. A lot of speedy trial challenges and everything associated with the way that time could affect a case. I think they're going to be throwing it at the wall and seeing what sticks. So the pandemic is going to have a long-lasting effect on the court system. I think a lot of it is going to be for good. But to your original question, I do think we're going to see courts going back to normal. I personally would never in a million years want to try a murder case under the conditions that people have been doing it over the last few months, not being able to see jurors' faces and not being able to stand up and address them. Part of prosecuting a case is being able to relate to a jury, and it's very difficult to do sitting down at a table with a mask on.
Yeah, absolutely. And I agree. If you can't see the jurors' faces or the defendant's face, I do think that is something we might see on appeal. But I have to ask your opinion while I have you and your thoughts and can pick your brain about Zoom, because as a judge, when I fill in, I still do hearings by Zoom, in part because of the Georgia Supreme Court order here in Georgia. And I must say that there have been some real benefits. I'll give you an example. Parents' involvement in hearings has increased because it's easier for them to participate. The number of children participating in hearings has increased for the same reason. So with the right precautions in place via Zoom or other virtual means, and with the right caveats in terms of nobody has any objections to that, I think it's a very good thing to take forward and move the ball forward and have certain types of hearings via virtual means. As a trial attorney, do you think that that's a reasonable thing to do moving forward?
Absolutely. There are going to be kinks, right? I think part of the reason technology is not advanced in the court system as compared to other sectors is because of the reluctance on practitioners and courts to make the change. But the force of the last year has created an opportunity. And I think that if courts and practitioners look at it as an opportunity, we'll continue to get better at it. And the benefits are clearly there. I know there was those days, I think those days of 20 lawyers lining up in a hallway to wait to talk to a prosecutor for 10 minutes are over. I don't think we're going to see those again. At least I hope not. For the client's sake. I mean, everybody's billing 3 hours for 10 minutes of work of sitting in a hallway waiting to talk to a prosecutor. It's pretty unreasonable, in my opinion.
Yeah, I absolutely agree with you. There's some benefits to that, and take away the commute time for so many attorneys, and they can have the hearings from their own office versus commuting to the court. That can make a difference too in terms of time to prepare. The other piece of that, and Melaney, I'll turn to you if I could please, when we have all of these virtual hearings, I think too, it allows, let me rephrase it, nationwide, right? I hear from some courts, we've got all this equipment that's been sitting on our desk and we've never used. And so let's finally start using it, yay. And then I hear from some other courts, we don't have the funding, we don't have the money, we cannot implement all these virtual hearings with the right precautions or ensuring everybody can participate correctly. So I think that they're both sides. What are your thoughts on that piece, Melaney, and the equipment and the receptiveness and people being able to actually participate?
I think it definitely depends on the counties and where you are located, because just like you said, Judge Ashley, I'm in Georgia as well, and in Gwinnett County, they are all for continuing via Zoom or WebEx or some sort of virtual technology. A lot of the judges we've even met with, they said that it's more efficient and more effective for them. They're getting things done, in a faster time frame. And us as criminal defense attorneys are allowed to, go into breakout rooms with prosecutors, get things taken care of very effectively. And so I think for any of the counties that, let's say, do not have the technology, or they have it, but they do not want to attempt to implement it, I think they should definitely try it and see if it would be more cost effective for them.
Yeah, excellent point. I want to turn our attention now, speaking of, because with virtual hearings as well as in person, really it's incumbent on the judge to manage the courtroom, to follow the rules, to make certain everybody there is following the rules. And this judge, Judge Atkins, I really appreciate. He's kind to the jury. I'm not going to keep you late on a Friday, takes that into account. But then he was fairly terse and said to the defense attorney with the last witness of the day, move on or sit down. And the defense attorney pushed it a little bit more and he said, that's it, move on or sit down. If I could ask you, Melaney, I know you're going to have to leave us shortly. What were your thoughts, or are your thoughts, about this judge in this trial?
I think he's very efficient. I mean, he is listening very closely to the testimony and listening to the defense attorney. And in that particular instance, he heard that the investigator answered the question. He answered the question multiple times. So at that point, he's telling the defense attorney, look, move on, because we've heard enough of this. And that always, in our minds as defense attorneys are like, okay, well, we've kind of gotten to that level where we should just let it go. And so the defense attorney let it go.
All right, Jamie, any last thoughts in the last 30 seconds or so about the judge from your perspective?
I think I'm going to hold judgment at this point in time. As far as his comments to defense counsel, it would have been my preference to see him get a little latitude. I don't disagree that maybe he was asking some questions that had already been answered, but with a triple homicide, in my opinion, judges should show a little discretion.
All right, so I really appreciate both of you being with me. I know, Jamie White, you will stay with us. Melaney LaGrone, thank you for being with us this afternoon. We will take a break now, but when we return, we talk about the final moments of court in Kentucky versus Christian Martin. We'll also take a look at the latest developments in Minnesota in the Derek Chauvin case. You won't want to miss it. We'll be right back on Court TV, your front row seat to justice.